I'm Attorney General Alan Wilson. I want to thank all of you for being here today. I'm here today to talk about some reforms that I have been advocating for, not just this year, but over the last 15 years. Some of these reforms we picked up more than a decade ago, and they fell by the wayside due to special interests. Other reforms have been picked up and taken part way to their full completion and not completely gotten to where we wanted them, and I'm going to talk about those momentarily. But before I talk about what I'm going to do, I'm going to talk about my process. Every year, I preside over an office that has about 350 employees, 90 of them lawyers and prosecutors, working with law enforcement agencies in all 46 counties and 16 circuits, as well as state and federal law enforcement jurisdictions. And every year, they come to me and they say, General, these are the reforms that we would like. These are the laws that we would like. This is the funding that we need. These are the resources and the tools that we need to protect South Carolina families. What I am calling for today is that we reform the selection process for judges. The Judicial Merit Selection Commission, which is a system that is mostly controlled by the legislature. Last year, the governor was given some appointments on there. But the process for nominating judges should be completely under the executive branch of government. All of the commissioners that preside over that commission should be under the executive branch of government. All of the staff members who review the qualifications of candidates for judicial office should be under the executive branch of government, should be completely controlled by the executive branch of government, and then all of those nominations will go to the legislative branch of government. This is important because everyone can vote for their House member and their senator, but they cannot vote for the other 168 members of the General Assembly that weigh in on that. But everyone gets to vote for and against the governor. Everyone gets to weigh in directly on the executive branch. This is as close to the federal system as we can get under our current Constitution in South Carolina. In addition to moving the selection method under the executive branch of government to give more accountability to the people, I'm also calling for a couple of additional reforms. First, I'm calling for the governor to be given one extra judicial nomination for every single one of the 16 judicial circuits in South Carolina. That is 16 extra judges that the governor can nominate directly to the JMSC that can then be fed out and nominated to the legislature to be voted on. Why is this important? If you look around the state of South Carolina, there are circuits that are more rural and there are circuits that are more urban. You have situations in when you have one or two judges presiding over a 4 or 5 county circuit, and then you have other circuits where you have 5 or 6 judges presiding and holding terms of court in 1 or 2 counties. Oftentimes, the more rural counties get overlooked, and they have less resources. They have less ability to be able to move these cases. They have overcrowded jails that are tapping the resources in those areas. We also have a higher number of people in urban areas. So I believe by adding the number of judges by 16, we're going to create 16 additional terms of court that can move the backlog of violent criminal cases. I am asking the General Assembly to continue to fund my violent crimes case reduction unit so that we can continue to work with these new judges so that they can move the backlog of cases. Because at the end of the day, when a victim has to wait 3, 4, 5 years because of a violent crime that was committed against them or their family member, justice delayed to them is justice denied to them, and we can do better. In addition to these reforms for the judiciary, I am calling on the General Assembly to create a vehicle for a retention election. Oftentimes, when a judge is elected to the circuit court or to the Supreme Court, they have anywhere between 6 and 10 years to serve. They will not come up for another vote for 6 or 10 years. We need to have the ability, when a judge violates the judicial canons or is habitually drunk or habitually abusive or refuses to keep violent criminals in jail when the law otherwise requires them to keep them locked up, there needs to be a vehicle for calling them to the General Assembly and calling for a basically vote of no confidence, a retention vote. This gives the legislature and the executive branch a quality control check in the middle of that judicial term. Whether it's a call by the governor or a built-in retention election in the middle of the term, it gives the people the ability to do a quality control check on judges in the middle of a very long term. I would also call for the creation of a judicial ruling transparency report, which would basically publish sentencing patterns and rulings before the reappointment process begins. So this judicial ruling transparency report would give the people of South Carolina full transparency and give the legislature and the governor and the executive branch agencies full transparency on how judges are ruling on whether they're letting violent criminals out or what the average number of years they're giving in a sentence. This gives us transparency. We do this for the legislature. We do this for executive branch officials. We need to do this for the judiciary as well. I believe that these reforms would go a long way to bringing balance and parity of power to the three branches of government, and would also give more accountability to the people of South Carolina. Another thing I'm going to be calling for on the bond reform. Now, back in 2023, the General Assembly did a really good job of passing some enhancements for bond reform, but we need to continue to enforce no bond for violent offenders and repeat offenders. People who come back with a repeat violent offense do not need to be let out on bond. There is a law on the books, but that does not always happen. Again, with the judicial reforms that I just talked about, we can better hold these individuals accountable. I'm calling for the ending of cashless bail for serious offenses in South Carolina. Ending cashless bail for some of these serious offenses will provide additional protections to people living in their respective communities. I'm also going to ask and call the General Assembly to pass a law that requires judges to justify the release decisions when granting bonds to violent or repeat offenders. That needs to be on the record, and we need to be able to see it. In 2023, there was a bond reform law called Act 83. It basically created a pretrial reform commission. This pretrial reform commission was supposed to go into effect last summer, and it was supposed to make findings and recommendations to the General Assembly. I don't know that this pretrial reform commission is met, but it called for members of the judiciary, the executive branch of government, the legislative branch of government, as well as the victims advocacy community and people involved in pretrial processes in the criminal justice system. They were supposed to come in, create a commission to monitor and track many of the things that the legislature is voting on. I don't know that that commission is met, but I think it should be permanent, and I think it should be standing, and I think every year it should be required to do a report to the General Assembly on findings and recommendations on the state of our criminal justice system. That way, the legislature and the executive branch can keep, and the judiciary can keep their fingers on the pulse of how well our criminal justice system is serving the people of South Carolina. I'm also calling for major sentencing enhancements in the area of child exploitation crimes. This is something that has been very near and dear to my heart. Over the last 15 years, I have increased the size of the Internet Crimes Against Children Task Force by 400%. We have quadrupled the number of investigators and forensic analysts and prosecutors in our office. We've tripled the number of agencies from approximately 40 to around 125 or so agencies in South Carolina, which has led to the prosecution of 2,600 online predators and pedophiles. But every year, I meet with members of our respective criminal divisions and civil divisions, and I ask for them to give me feedback on what they would like to see. One of the things that we would, and some of the information that they gave me, is to give law enforcement and prosecutors additional tools to hold those accountable who are using the internet and social media platforms to prey on the most vulnerable in our society, our children. So, currently, under South Carolina law, first-degree exploitation of a minor has a mandatory minimum of 3 to 20 years. My proposal would be a minimum of 25 years in prison. If someone is raping a child and causing sexual abuse to a child, they get a mandatory minimum of 25 years. If you're coercing a child or producing child sex abuse material, basically child porn, the penalty should be just as stiff, because these are the people who are capable of manufacturing child porn are also capable of raping children. That needs to end. 25-year minimum for those types of individuals. Second-degree exploitation of a minor is currently a mandatory minimum of 2 to 10 years. I am advocating for a mandatory minimum of 10 to 20 years for second degree. These are people who distribute child porn. First degree is manufacture, second degree is distribution. If you're in the distribution business for child porn and child sex abuse material, then you're feeding the market, you're feeding the demand, you're creating new child predators by facilitating that. We need to raise the floor to 10 years, and we need to raise the ceiling to 20 years. And I'm advocating for that under second degree. For third degree exploitation of a minor, it is currently 0 to 10 years. More than half the states in America have a tiered system under possession of child sex exploitation. I am calling for a mandatory minimum of 5 years for anyone who is a repeat offender for possessing child sex abuse material. Mandatory minimum of 5 years if you come back into our system. I talk to my prosecutors, and the one thing that they say is they see a lot of repeat offenders. So they've asked for the additional tool to get a mandatory minimum and put these predators and these people who are possessing this filth in prison for at least 5 years. We also are calling for a tiered system under the possession of child exploitation, which is currently 0 to 10. We want to give sentencing enhancements based on the age, violence, and quantity of photos and videos held. So it could start at a certain level, and based on the severity of the possession of child porn, it could go up to 7 to 10 years, from 0 to 10 to 7 to 10 years, giving law enforcement charging decisions, greater charging decisions, and giving prosecutors greater decisions on how to prosecute these people would help us hold them more accountable. If you do this once and you come back in, you will not see the light of day as a free person for at least 5 years. Another thing that I have called for in the past, and it's already in law, so we don't need to pass the law, but that is the death penalty for people who rape young children and are a prior offender. If you commit a sexual assault against a young child as a repeat offender, our law calls for you to be put to death. South Carolina currently has a death penalty statute for repeat child rapists who are sexually assaulting young children under the age of 11. In 2008, the United States Supreme Court ruled that laws like this are unconstitutional. That U.S. Supreme Court was wrong. That is why I'm looking for a test case to give the Supreme Court, this new Supreme Court, a chance to get it right. Because if you're capable of raping a child, and if that child has the fortune of not dying, you don't get put to death. So if that child dies, you get put to death, but if that child doesn't die, you get a pass. And I believe that we need to implement the death penalty for people capable of doing that to the most vulnerable in our society. Now, another thing I would like to do is talk about how complex our criminal justice system is and some of the things we can do to put guardrails to protect our citizens. In South Carolina's criminal justice systems, there are many cooks in the kitchen. At the state level, you have the Attorney General's Office, the State Law Enforcement Division, the Department of Public Safety, the Department of Probation, Parole, and Pardon Services. You have the Department of Corrections, which oversees 21 state prisons. You have the Department of Juvenile Justice. You have court administration. You have 46 county detention facilities, 46 sheriff's offices, approximately 250 police departments, 16 solicitor's office, and roughly 62 circuit judges, and approximately 300 magistrates, all in the kitchen of the criminal justice systems. At the federal level, you have the FBI managing the NCIC system that produces the rap sheets. You have thousands of people with inputs into the criminal justice system. And all it takes is for one of those human beings to make a mistake feeding into this information. Garbage in equals garbage out. What we need to do is what other states like North Carolina are doing. We need to establish a state-of-the-art integrated criminal justice information program similar to CJ Leads, which is a program that North Carolina has implemented. It allows for all of the vast levels of jurisdictional levels in South Carolina criminal justice system, from local, state, and even federal. It allows for the multiple branches involved, the judicial branch, the executive branch, and even the legislative branch, to have the ability to go to one system to see when a defendant enters the system, sometimes that the sentence rap sheet could omit valuable information based on how the information was put at a county detention facility. Sometimes you might have information go to a public index. There are 46 public indexes, so if a solicitor or a law enforcement official are having to go look at the public index to determine how bad a person's prior record is or their criminal history is, they would have to go to 46 independent, separate public indexes. We can do better. There needs to be a statewide, integrated, controlled, centralized system that collects all of the criminal justice information that you can go to, a one-stop shop for finding out who the criminals are, what their history is, and that way judges and prosecutors and law enforcement officials can make bad decisions. There will always be people who make bad decisions because they're bad at their job or because of their philosophy of governance or law enforcement. But there are a lot of people who want to do the right thing. There are a lot of people who care, men and women who put on the uniform, prosecutors, judges who are passionate, compassionate, they're dedicated, they're hardworking. But if they're making decisions on flawed information, then their decisions can be just as bad as someone who doesn't do their job well. We owe it to them, and we owe it to the people of South Carolina to put in guardrails using advanced technologies, centralized integrated platforms, maybe even using AI to give the most information and the most complete picture of a criminal defendant to the people making decisions at that moment in time. We must reform this system. We must protect South Carolina families. We must give law enforcement and prosecutors every tool that we possibly can to ensure that our state is safe. We must pass these reforms. I'm happy to take any questions that some of you may have.
General Wilson, you mentioned the role of special interests in slowing the passage of criminal justice reform like you've been talking about in the past. Who are these special interests and why will this time be different?
So first off, when I advocated for judicial reform 2 years ago, I will say this, and I'm going to be fair, and this is a bipartisan statement. There were Republicans and Democrats against judicial reform last time. There were Republicans and Democrats for judicial reform. I had some attorneys who serve in the legislature advocating for judicial reform. I had attorneys who were legislators advocating against judicial selection reform. For me, the special interest might come from people who stand to lose power if they lose the ability to control the selection and the vetting mechanisms. And I'm not going to call out individual names because at the end of the day, I think most people want to have good government, but there are some people out there in all three branches of government who benefit from the current system. And my job is, it's not about benefiting any one group or special interest or stakeholder, it's about benefiting the people of South Carolina.